6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.
Hey everybody, welcome to the True Crime Squad. I'm Kristi Brower, here with my sister, co-host, and partner in crime, Katie Weaver, when she gets here. She will be here. She's running a little behind, but we're just going to get started. We have a lot of to talk about today. Obviously, we were hoping we were going to be trial streaming for Lori Vallow, but that is not what happened. Rather than explain it all, I thought, you know what? Let's just watch it together. Because this is bullshit. So here we go. Let's hear what Lori and the judge have to say.
Set for continuing jury selection, State of Arizona versus Lori Daybell, CR 2022-001242. Appearances, please.
Kristi on behalf of the state, for the record, the victim is in the victim room watching.
All right. Ms. Daybell?
No, in the courtroom, sorry.
Lori Daybell for the defense.
All right, are we ready to proceed with jury selection?
No,
Why not?
I'm sick, Your Honor. I've been sick all weekend. I let my team know yesterday I was sick.
Can you please pull the microphone a little closer? I can't hear you very well.
I'm sick. I've been sick.
Have you put in tank orders to get treatment?
Yes.
Are you being housed in the infirmary?
Nope, I'm housed where they put people in quarantine anyway. I'm housed alone. They would not move me from where I am.
Have they tested you for any communicable diseases?
No.
All right.
Yeah, that all sounds
You
very
asked me
fake
to
to
let
me.
my team know. I let them know yesterday at 9 a.m. that I was still very ill.
Sometimes we're in positions where we have to proceed when we feel under the weather.
It's not just under the weather. I'm very, very ill.
Do you have copies of tank orders you put in for treatment?
Not with me. I put it in on the tablet.
Was the DO able to check whether any tank orders were put in? What's that?
I think it takes about 24 hours.
They haven't even answered my tank order yet. It takes them a long time.
We're listening to Lori whine.
She's very sick. Can I have a new judge yet?
So what symptoms are you having?
I have a terrible headache. I have nausea. I have chills. I have a fever, probably. I haven't really been able to keep very much down besides broth and oranges.
A tank order is an order for medical treatment.
Would you be willing to have one of your advisory councils complete the 40-year process jury selection?
Would that waive my ability to represent myself for the rest of the trial?
No.
Then can I have a moment to discuss with them for a second?
A couple things. I'm your trial judge. My instructions are to complete your second trial. So even if for some reason your sickness worsened and we weren't able to complete this trial and had to declare a mistrial as this trial, even if this case got delayed into June or July or August to be reset, I'd still be your trial judge.
It's not gonna work, bitch.
Nope.
Additionally, last time we did jury selection on your first trial, as I recall, you asked between probably about 5 and 10 minutes of follow-up questions of the panel before we sat the jury. I only mention that in the context of not a lot of it is expected of you at this point in the trial. Depending on how you're feeling later, we could talk about whether the opening statements would have to be further bumped to.
Sorry, this buffered for a sec. It's not very long.
Yeah, there was a lot of sighs from the judge.
Oh, yeah. It surely was.
But just so
Tomorrow.
you know, I'm still your judge.
But I would like to keep this trial on track. So if you want a few minutes to talk to your advisory council, we can do that. Is there anything the state wants to put on the record before we do that?
Not at this time, Your Honor.
All right. Do you want to do that back in the tank? All right, we'll be recessed for a few minutes.
All right.
Please be seated. All right, we're back on the record. State of Arizona versus Daybell, CR 2022-001242. The state is present. The defendant is present. Ms. Daybell.
I did discuss with my advisory council. They are not comfortable doing that. I do have a right to represent myself. I'm sorry that I'm sick. I did not plan on getting sick. I did not try to get sick. This isn't anything to do with anything other than the fact that I'm incapable of going forward and
Incapable,
doing a
for
good
sure.
job representing myself.
We know
I've been
that.
incarcerated for over 5.5 years. I've only ever been sick one other time in the whole time I've been here.
All right. State want to be heard?
Judge, obviously, if the defendant is sick and she does have a right to represent herself, we understand that. The concern is the state does need a date certain when we're starting. I have witnesses that I rescheduled already once to fly in this week, assuming we were starting today. I obviously will need to reschedule them again. I can't keep rescheduling them every single day onto a new flight. So I am not sure how we want to proceed at this time. If we want to give the defendant a couple days, see if this jury is available to extend out to the 25th. I know we had originally talked about that, and begin on Wednesday. I don't know if she will feel better by then, but that's the only suggestion I have at this time, other than starting all over again at another date.
Is there a reason I couldn't proceed with some of the oral voir dire this morning? Because other than introducing herself, she wouldn't be expected to do anything this morning, and that way we can at least get rid of some of the jurors that, for whatever reason, would need to be excused.
Judge, my concern is she's in a wheelchair now.
Well, I would probably ask to have her sit in a regular seat and not be in a wheelchair that says MCSO across the back of it.
Smart.
Your Honor, I am just not capable of going or even sitting here. I need to be laying down. I need to be getting better so that I can go forward and actually represent myself. I hope that I feel better this week and we can go forward. I can't give you any promises. I can't control any of this.
Except I am by doing this.
Sucks to suck, Lori. I guess you shouldn't have been so murdery.
Yep. Right, Kathy, her voice does keep changing. She's all pathetic, and then she's like, but Your Honor, like, come on. Right, Aaron, some of you guys are saying, you know, this is all because she didn't get her way last week. I think so. I don't believe her. I don't think she's this sick.
Oh,
The
this
jail
bitch is gonna,
transported her.
Yeah. This bitch is going to file down the road that yet again for this case to be thrown out because her constitutional rights were violated by not getting a speedy
All right,
trial.
I'll take the state's suggestion and try to salvage this jury in this trial. I'm sure these jurors are going to be none too happy coming down today again for a dry run.
Judge, I do have one other. I don't know if we're able to, and I understand this is Judge Kemp's courtroom. If we can start earlier for the rest of the week and next week at 10, maybe take an hour for lunch. It's just ways to try to.
Yeah, I would be willing to do that. So for Friday, I have nothing else, and Judge Kemp has nothing. We could start at 9 on Friday.
And I know we have at least one juror that we will have to excuse who was going camping on Friday.
Juror number 4, I think.
Yeah.
My schedule, we could start at 10 on Wednesday. Let me check Judge Kemp's courtroom schedule.
Right, Marta, I was thinking the same thing. The jail would not have sent her out if she's puking. Come on.
I think he looks like he'll be done by 9:30 at the latest, so I think we'd be safe on telling the jurors to come back 10 a.m. Wednesday, get the jury picked, opening statements done. All right, I think I do need to bring the jurors in to tell them something, so can we have Ms. Daybell sit in a regular chair and not and bring the wheelchair out into the hallway?
Yeah, try to explain that.
She can't. She's too weak.
I don't think that I can even sit here. I need to go lay down. I don't understand. I don't think last time you said it was going to be 15 minutes. It was an hour and a half where I was sitting here trying not to throw up on TV in front of the jurors.
Which maybe we could, all of us leave and they could come in and just speak with you.
That's fine.
I've had that happen before where none of the parties are here and the court just advises that we're unable to proceed
Your Honor,
today.
I don't know about you rescheduling this for Wednesday. It puts a lot of pressure on me to be better and ready for Wednesday, and if I'm not, I don't like to disappoint people. I don't like putting people out of their way, all the jurors and all these things, and all the pressure is on me. That's not going to help me get any better anytime soon.
What is your suggestion?
I don't know, but I'm saying if I were, so tomorrow, if I'm not better and I let my team know, are you going to drag me in here like you did today with the
Drag me in.
team that came to get me? You know, they felt so sorry for me to have to get dragged out of bed to be here.
Yeah,
jail
the answer is
transported her.
yes.
They
I
could have
probably
called the
will
courthouse.
order that you be here Wednesday. We'll take tomorrow off. Because I need to confirm how you're feeling. You because you represent yourself, no one else can waive your own appearance.
You're welcome to come over to the jail and come to my cell and see how I'm doing in there.
All right, I'll take a pass on that.
Yeah.
All right, with the consent of the parties, then we'll have the parties exit. I'm going to tell the jury we're going to try to get this done on Wednesday, obviously that depends on whether the defendant's feeling better or not. We will, I'll tell them to be here ready to go at 10 a.m. Wednesday unless they hear something else. So I'll go ahead and ask the parties to exit. We'll keep the FTR running. If you're
Damn you, Jesus. You have just let your best friend down.
That was good, my 2 cents.
Yes, it was. Also, how is she a translated being? I'm getting so sick. You're right.
That's not supposed to happen
Also,
at all.
she didn't cough one time in that entire hearing, but she's can barely speak into the microphone. Give me a fucking break.
But then she
She is
can
not that sick.
speak quite clearly and sass pretty good. So
Yeah. And if she was really like actively puking, there's no way the jail is going to transport her. They don't want that in their transport vehicle or to deal with in the tank where they hold her there.
right. Well,
I don't
because she
believe
may
it for a
not be the
second.
only inmate as well
Right.
that they're
Yeah.
transporting, and they don't want to expose everybody else to her nonsense. And yeah,
Yeah. And they couldn't confirm that she had applied for the tank order to try to get treatment. No one could confirm that. I don't believe it for a second. And you can tell the judge doesn't either.
And I loved how he made it very clear to her that I'm still going to be your judge no matter what. So,
oh, interesting. Okay. So some people, because you really can't see her. That's terrible video. That she was holding her mask and not even putting it near her face. So she wasn't actually wearing a mask. Yeah, she was deathly ill.
yeah.
Nate said she was bawling in court. She's just had her ass burned.
She
didn't get her way. And this is her trying to punish everybody.
Somebody else wanted to know if Lori Aliverdian is going to show up in court on Wednesday in
I know.
oxygen.
My first thought was, oh my God, she's acting like Nick Rossi in that fucking wheelchair.
Yep, she is.
Well, they're trying to be careful. They don't want any reason for her to use this as an appeal. And that's what she's trying to do. Part of it. I loved that he immediately addressed hey, if we have to delay your trial because you're so sick, I'm still your judge, bitch. This won't work.
Nope. Well, and also if I'm still sick, are you going to drag me out of bed and drag me into court? And he said, yes, I will.
Yes, I will. And by the way, it's the jail who transports,
Yeah.
They could call the courthouse and say, she's really sick. We can't bring her.
Or she's really sick. What do you want us to do?
Yeah.
But none of that happened.
She's going to puke in the transport van. We don't really want that. None of those things happened. Yep. So, yeah, I do not believe her.
Yeah.
Not for 1 second. The way that she started it, Your Honor, I'm so sick. I can't do it. Give me a fucking break. As soon as she got annoyed, her voice got much stronger. Weird.
Funny how that works, Lori.
Yeah.
When the judge asked about her symptoms, I thought, murderous, delusional, evil.
She's got all the symptoms, guys. She's got nausea, vomiting. She's got fever, probably. And terrible headache. Yeah, you are a terrible headache. You know who has a terrible headache now? Judge Boreski. That's who.
And here's all the ladies in murder prison on death row with her that are just being exposed to this too.
Right.
Wow, Lori.
And they haven't tested her at the jail. Well, they don't want a COVID outbreak at the jail, so they would have tested her if they really thought she was that sick. I mean, there's just
Thanks, my
just
2 cents.
Isn't the case. Oh, thank you for the tip. We appreciate that so much. The super chat is on. So
this was just super wild. I can't wait to see what happens next.
I know what's going to happen on Wednesday.
Well, and a couple things when the judge did bring the jury in and speak to them, which, by the way, Prosecutor Kay, as always, big 2 thumbs way up.
Class act, always.
Yep.
Yeah.
But when he addressed the jury, he told them that he was very embarrassed to do this to them, that this has never happened in one of his courtrooms before. Yeah. And that if they come back Wednesday and he sees the jury, he will buy them donuts. And one of the jurors said, that'll work.
Well, I mean, it is. What a pain in the ass for them.
Right.
Because this
Wednesday,
is pushing
Monday, or
that time frame
Friday,
further out,
Monday.
further out.
Yeah.
Yeah. And that she wouldn't even sit there and let them do the voir dire parts that she doesn't even have to do.
Yeah.
Like, come on.
Yeah.
Give me a break.
Yeah.
Shannon says she's going to pretend that she's possessed by a demon and put on a show. Who the fuck knows at this point? The thing that is, this is just about her needing to be in control, because what the fuck, bitch? You're going to prison forever, regardless of what happens in this trial. This is your smallest charges that
you're
you've
fighting
got.
these the hardest. Yeah.
Yeah.
And acting up the most. Maybe this is just her last hurrah though, so maybe that's part of what it's about.
Yeah, I guess it is. It's just her last chance to get a bunch of attention. But I just don't buy that she is as sick as she's saying. I just don't believe that the jail is going to put up with a puking inmate to transport and to deal with at the courthouse and to be exposed to other people. They're just not gonna. They're not taking that risk.
For sure. Also, she claims she's been sick since Friday. They broke court on Friday because she was sick. She said she's put in the note for the evaluation but hasn't received it, the medical care. What day did she do that?
She didn't do it until Sunday.
Yeah.
She waited until Sunday, and it takes at least 24 hours for response on it. Because, you're in jail, you dumbass. Like, they don't.
Excuse me. She's in prison
jail.
jail.
Alive, but they don't really have to care about you at all. Right, exactly. That's what I think too. My cat's name is Karen. The jail has medical staff, and they wouldn't have let her go if she was contagious. Right.
Unlikely.
But
Yeah.
she hasn't been tested for anything, which makes me think they're not worried that she is contagious.
Bet you when she gets back to the court, or when she got back to the courthouse today, they immediately jumped
I would imagine.
on that. The judge was probably like, you better get her under control right now.
Right. Exactly. Yeah. Because this is just her controlling the court some more.
Yeah.
So I don't know.
Well, but also trying to avoid doing things she doesn't want to do. Do you guys remember what happened the very first day of her trial in Idaho? As soon as they started pulling up pictures of her dead children, she suddenly needed to leave and tried to refuse to be there. Yeah.
Yep.
When there's parts she doesn't like. And like somebody in the chat said, her victim this time is alive and well and sitting in the courtroom.
Yeah. Yeah. He was present. Just shitty to everyone. Poor Brandon has had to be there in case, and now this bullshit. Right. Give her some IV fluids. Throw some anti-nausea meds at her.
Yeah. Give her an antibiotic shot just for good measure. Yeah.
But like the judge said, he said, you're representing yourself. You can't waive your appearance here unless I see you. You don't have an attorney to do that for you.
Yeah.
Yeah.
Yeah. Right. That comment. If you only saw how bad the jail people felt having to make me get out of bed and come to court today. The judge is like, bye-bye.
Whatever. Right. Exactly. This is a temper tantrum. What the hell? Well, speaking of temper tantrum, the other thing we wanted to share with you tonight, since we didn't have any trial coverage to talk about, is the hearing that happened last Friday, where she was as ignorant and sassy and arrogant with the judge as she has ever been. I only saw the very beginning of this. I didn't watch all of it because I wanted to blind react it. I watched the first part and was like, holy shit. So we're going to share that with you now and do a little blind react for you.
Absolutely.
So let's see. She was terribly ill on Friday too, guys. I want you to see if she seems ill to you.
Phase from my understanding that we did over my objection last time.
Well, we actually didn't do an aggravation phase.
I stipulated to it.
You stipulated to it.
Correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances. right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been brought to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase, and that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, I have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty.
Don't you love how sure of herself she is when she doesn't have the first clue what she's talking about?
She doesn't. She's full of shit. She's also mixing up the first trial and the second trial.
Mm-hmm.
Like, your first trial's over, lady.
Mm-hmm.
But she
That's
keeps
all
referring
done.
to things that kind of apply to it. Like,
Mm-hmm.
what the hell are you even talking about? And if they find you guilty, guess what? They will have proven the aggravators that they are alleging. That's part of the deal.
Mm-hmm. Yeah. This whole conversation just slays me because she is just so damn confident and shouldn't be.
Of the charge, and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
In the jury instructions.
Okay. Hold on one second.
A little off the shoulder for her buddy there. Gross.
Your Honor, may we have just a moment?
Yeah.
The way she speaks to the judge and treats him is so disrespectful.
Such
I'm
a
sure it
rude
absolutely curls Prosecutor Kay's hair that she is getting away with this.
Right. Yes, and her hair was curled at court today.
Yeah.
She was deathly ill, but she didn't appear deathly ill. Come
Mhm.
on.
Yeah.
Also, she doesn't sound sick, does she?
No.
But she said
Not
on
at all.
Friday she was sick.
Super duper sick. Yeah.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases.
Telling the judge the law
Yep.
again.
I know in capital cases they call it a Cronus hearing, but this is for non-capital case.
You know, I really like Boreski as a judge, but I would love to see him as a prosecutor. Wouldn't you love to see him
Yeah.
try a case?
Yes, I would.
Yeah.
It's great.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a
Correct.
probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5B talks about amending the charge or the indictment.
Mm-hmm.
Okay. Your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
it's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause finding.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intent.
Do you see her face?
And her hands.
And her hands and the
Death grip.
eyes.
I don't know from that shit. I'm not going to kill this idiot, but I want to so bad. Oh.
She looks as annoyed as that day she said she had to look up one of Lori's so-called experts on Google. But carry on.
Intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these specific
Can I finish
aggravators
what I
are
said?
different,
What I was saying?
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it,
Yeah.
it's not a dangerous crime.
He fired the gun, dumb
So-
bitch.
No dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these
May or may not
aggravators
have
that
been.
talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing.
I mean, here we again have the judge in a position where she's demanding that he teach her the law.
Right.
It's not his job. It's
Teach
not
her
his
how to be an attorney.
responsibility. No. I mean, he's being more generous with her with his time right now and his knowledge than he has to be.
Right.
And she's repaying him by being a complete and total hose beast. I mean, I just don't
Right.
get it, Lori. I
No.
really don't.
Well, and yeah, somebody said, look at how that advisor's backing up away from her. Oh, yeah. He's like,
Mhm.
I don't want to be any part of this.
Yeah. Yep.
Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but
And she's
I would
supposedly
like to
sick
finish
right now.
this first.
Yeah.
So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts.
you're not entitled to one.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's an
between.
extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These aggravators.
That's exactly my point. How after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
Probably nothing in reality. You just said it. They don't change the charge, so you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can.
How are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend.
Problem solved.
Don't come.
else?
We'll do it anyway.
She can just stipulate to it like she did the last time. Like, God, she's a cow.
All right.
Ugh. Right, she says with her handcuffed
Something
hand.
dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets.
It's again.
Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check into and there's no more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want
You already
to have
get
beside
2
yourself.
more than
choose
anyone
one of
else.
Your advisory council
Jesus.
or your paralegal.
You're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Oh my God.
Okay, yeah,
I
did,
need them
in
to help
case
me. Also,
you
I didn't want
decided
them.
not to represent yourself so they could step in at trial.
Okay, well then, is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think
time?
it depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes.
Well, and you're a quadruple murderer. No one wants to stand next to you at the bench, you crazy bitch.
I mean, really, truly,
Don't
you're
forget,
not
you're a
supposed to
dangerous
be.
person.
Yeah, you're not supposed to get that close to the judge.
Yeah.
And we're protecting him at all costs right now, Lori.
And nothing is ever good enough. I want them all to have headsets. By the way, I never wanted them in the first place, and you made me have them. Oh my God. Gaslighting.
You said you'd look into that, did you?
Talking over him.
Ooh.
Oh.
If you weren't already in jail, my dear, you would be now.
Yeah.
We can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
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 I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is,
Oh, you mean how you lost?
what does the state intend
Is that what you're talking about?
bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when...
Accused by you.
By you. Oh my God.
Listen, I really do hope he laughs all the way home. I really do.
I hope so. I hope he can see some humor in this because Jesus Christ.
Yeah. And yes,
I
Attorney
just wanna
K
smash
must just
balls.
be... me too. I can't imagine what Prosecutor K... She is absolutely... she does laugh all the way home. I'm convinced.
Yeah. I bet she does. Yeah.
Yes, and Colby... Yeah, Paula. Colby said this is how she's always been. Bossy and snarky and playing the victim and just hard to figure out how to navigate the mood of the minute. Yeah.
Well,
all of
and
this
never
really
take no for an
manipulative...
answer.
Yeah, all the manipulative, argumentative stuff. Yeah.
Yeah.
This is real Lori right here. This is how she talked to Dunderhead like horny, stupid Chad into doing the stupid stuff they did.
Yep.
Almost every witness has testified in my Idaho trial. And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay.
All right. Anything else?
That was it.
All right. We'll
That
see
was it.
everyone.
Look at that smirk. Lori, honey, you didn't win a thing.
She looks like she wants to kiss that guy. The look on her face, I was like, ew,
Mm-hmm.
she's showing her shoulder.
Okay, so I'm being
Sitting next to
informed
him.
that the jury commissioner said if the parties stipulate to not bringing in any jurors tomorrow, we can do that. Remember last time, though, we
Oh, this was on
screened
Thursday. I was thinking it was Friday. It was Thursday last week.
whatever number we had. A few of those people didn't show up, even though they were informed they needed to show up. So we have 66. I think because it's a shorter trial, we don't necessarily need 4 alternates, but maybe we should just in case. I don't know.
Judge, I would still want 4, given that we lost
We
2
lost-
in the first 2 days.
We did.
I don't want to waive any appeal issue that.
Well, that's what we have.
Mm-hmm.
I mean, she's a bitch.
She's terrible.
But
And
she's one of
ridiculous.
those people that just talks people into oblivion till they'll finally just give in to her because they've had enough.
Mm-hmm.
Except this judge, it doesn't work.
No, she did not gain the ground with him. She thought that she would.
No. She sure wants to. And she sure tries, but he doesn't let her do it. And I'm very glad because you can see that kind of gaslighter, narcissistic energy of I am just going to insist until you give me my way works. And it's worked in lots of relationships for her. And it's what's got her here.
Right, well, she gains a little ground in the argument, then she'll gain a little more and gain a little more and keep adding them up until pretty soon you've lost your whole ass. Yeah.
Well, it's so exhausting
Mm-hmm.
to listen to her and to have to respond back to her with all this bullshit and her pretending she doesn't understand what he's trying to tell her, which is also bullshit.
Mm-hmm.
She's just going to push until she gets what she wants. And
well, and now she really wants to keep aggravating this judge to prove that she was right all along. Like he just has it in for her. And
it just isn't going to work.
All the rulings that came out today. You guys want to hear what he ruled?
I know you're going to be stunned by all of this.
I'm not going to read these because it's long and it's late in the day, but I will tell you. Remember that motion that they seized the Jeep illegally in Rexburg?
Yeah.
Here's what the judge said. He said he explains how the pro se defendant fails to provide evidence on how the suspect vehicle in the Gilbert shooting was unlawfully seized. He says she could have attached warrants and referred to issues to support her statement. What? You mean you don't just get to throw all that spaghetti at the wall and something's gonna stick?
No, you don't.
And I love how now in his responses, he's like, well, here's what you didn't do. I like it. Then we have the motion to preclude the evidence of phone, data, and text messages. Again, the judge says the pro se defendant did not attach or include any evidence related to the warrant to challenge the validity of said warrant. And also, just so you know, Lori, yes, Alex's statements are admissible pursuant to Rule 801. Also, she wanted to unseal the state's motion in limine regarding witness Tammy Lachik. That was denied. Also,
no.
Her motion to dismiss for non-preservation of crucial evidence regarding Brandon Boudreau's Tesla door and window. Yeah, that was denied too. So, as usual, she lost everything because the judge hates her.
Yeah, apparently. Or just because she doesn't actually know how to write a legal argument because she's not an attorney. Yeah.
Yep. Hilarious. Yes, Elisa, the missing 15-year-old in Utah, turned herself in Colorado over the weekend.
Well, I'm glad she did. Her poor parents, my God.
Oh my God.
The charges against all these men are just racking up and they don't even know if she's alive.
Horrifying.
Jesus.
But yes, she is okay.
Yeah. So that is good.
Mm-hmm.
Oh my gosh, Sanders. I know. Lori's very frustrating. I know you're irritated, but you got to slow it down, lady.
So tomorrow we'll do a non-Vallow episode, believe it or not.
Shocker. I'm going to be talking about J.P. Miller.
Yeah.
And, that it turns out that there's another suicide that he had some hand in. Yeah. He is such a piece of shit.
Mm-hmm.
So I know I want to talk about that. Sanders.
I don't know yet, but I'll figure out what I'm going to talk about.
Yeah.
Yeah. Well, that was something. I think this is just a precursor to what this trial's going to be like. Holy moly. You know why it's going to be slow? Because of this kind of shit. This should be a fast one, but she is just going to keep malingering and causing all of these delays.
She is, because it's all she's got left. Mm-hmm. It's all she's got left. When this is over and her sentencing is over, bye, bitch, bye.
Mm-hmm.
Forever.
Yeah. Unless she defends herself in her appeal.
I mean...
At least she won't be Judge Bresky's problem anymore.
Godspeed.
Yeah.
Yeah. Absolutely. All righty. Well, that's our story, and we're sticking to it. We did just release 2 new Patreon episodes. If you haven't seen them, please go watch the Call Ahead Bank Robber that I put out, because what the fuck, man? I think DoorDash has ruined everyone, even bank robbers. Thinking you can order ahead. Newsflash. You can't.
You cannot. I covered a case from 2013 in which a bus driver essentially kidnapped a whole bus full of kids to make 2 kids fight. It's really something. I'd never heard of this before, but maybe you have. But I had some comments and some thoughts.
Yeah, that is a bus driver fight club. Who knew? Who knew?
Shouldn't be.
All righty. Well, thank you all so much for being here. Please be sure to like, subscribe, share, comment, leave a review where you can. You can tip us at truecrimesquad.com. You can also see all the stuff we have going on over at truecrimesquad.com. Mm-hmm. And we will be back with you on our regular Tuesday time, which is 3 p.m. Mountain. And you know it. We are the True Crime Squad. Thanks for being here.
Take care.
Season 6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.